So, let's go back to something that occurred a few years ago. In 2011, the IRS issued regulations mandating that certain tax preparers had to engage in certain conduct. They had to take 15 hours of continuing education, they had to take an initial qualifying exam, and they had to do background checks. Now, who did this require to do this? Well, CPAs, enrolled agents, and attorneys were exempted. Why? Because each of us have already faced this. All of us have a requirement for continuing education to continue our professional status. We all took some type of qualifying exam to get our CPA license, our enrolled agent certificate, or our law license. And as a predicate to each of those, we had a background check. But here's the problem the IRS faced then and now. They had about 800,000 people who did paid tax preparation in this country. And of that 800,000 people, only about 300,000 were CPAs, enrolled agents, or attorneys. So we had a lot of people who had never been tested nor had a background check that the IRS was seeing prepare returns. They were doing returns for fees, but they had not had any of these requirements imposed on them. Now, we know you're attending this continuing education class today, partly because you're required to get an ethics requirement for education, but also so you can stay current in your education and you attend other classes. Can you think of somebody who does tax returns, who can do a good job preparing returns, if they don't attend some form of education each year to keep up with all the changes in tax law? And certainly we'd want a test for anybody to prove at least the intellectual capacity to do tax returns given the complexity of tax laws. And would we really want convicted felons preparing tax returns? So, seemed like a reasonable requirement. These 500,000 people who hadn't proven their intellectual capacity with a test, had not undergone a background check, would have to go through both, and that they, going forward, they'd have to have continuing education to keep their tax knowledge current. In a case called Loving that was decided in 2013, the district court in D.C. held that the IRS lacked the authority to regulate the 500,000 unenrolled practitioners. That case was appealed by the IRS, and they lost the appeal in February of 2014 in the Circuit Court of Appeals for the D.C. Circuit. Soon thereafter, the IRS announced they would not pursue further appeals. So what we have now in many states is that very unqualified people can prepare tax returns. In my state, Illinois, there is no testing, there's no additional qualifying exam, there's no background checks, and there's no continuing education for the unenrolled practitioners who are not CPAs, enrolled agents, or attorneys. So we can have this situation as a result of the Loving case. We can have a person who's released from Stateville Penitentiary in Illinois after having served a 3-year term for robbing 7-Eleven stores. And once he gets back into society, he finds it difficult to find a job as a convicted felon. He goes to his family, he borrows money, he buys a tax preparation program, opens a small storefront with signs saying tax returns prepared, best refunds available, and he begins preparing returns. So there is absolutely no bar within my state law to that person entering into the tax preparation business without having had his background checked, and he is a convicted felon, and no requirement that they have continuing education or that they even take a test to prove they know what they're doing. Now, 5 jurisdictions have forms of regulation: New York State, Maryland, D.C., Oregon, and California. But the majority of jurisdictions in this country allow any convicted felon to open their office and begin doing tax returns. It's unfortunate. The basis of the decision was that they upheld, the D.C. court upheld the authority that the IRS did not have the authority to regulate tax return preparers. The key issue was whether the preparers were considered to be representing taxpayers. And Circular 230 is for the purpose of regulation. The court held that tax returns were not in the nature of representation. 7 former commissioners of IRS filed an amicus brief in that case, arguing that tax returns were so complex at this point in time that they are an advocacy document, that the ordinary taxpayer has to hire a professional because of the difficulty in doing the returns, and that professional is in fact acting as a representative. That argument was rejected by the D.C. Court of Appeals. Now, one of the things in the regulations in 2011 was that if a practitioner does more than 10 returns for a fee, he must file the returns electronically for the taxpayer or do an 8948 explaining why the return is done as a paper return. Circular 230 requires that every enrolled agent, CPA, or attorney who does returns for pay and does more than 10 must comply with this rule. But with respect to the law itself, there's no remedy against a unenrolled preparer not filing electronically, whereas for each of us we could be disciplined by the OPR. So it started in 2011 with more than 100, and then in 2012 filing season, which is the reason I have this particular form, it was for 10 or more. As part of the regulations, the IRS also required, when they tried to regulate everybody, that we all must get a P10 number. That has remained in effect, including those who already had a P10. Preparers included those who prepare claims for refund and don't do actual returns. Beginning in 2011, those preparers who are not EA CPAs would have to pass a test. Well, that was ruled against by the Loving case. It all began in September 2010. You must register every year. For purposes of obtaining a P10, only a tax return preparer is any individual is compensating for preparing and assisting in preparation of all or substantially all of a return or claim for refund with the IRS. Now, the one thing that occurred last year, that was in the year 2017, as a case came down holding that the IRS could not charge a fee for the P10 that's required. They could require a P10, but they couldn't charge us the $60 fee. And the court ordered that the IRS refund all of the $60 fees each of us have paid all the way back to 2011. That case is currently on appeal, and the court stayed the requirement that the IRS give back all that money while it was on appeal. So bottom line, right now, the law is the IRS can't charge a fee for P10. Those of you who re-registered last year were not charged a fee, but potentially, depending on the outcome of the appeal of the IRS charging a P10 fee of $60 a year, you may get a refund of those funds that you paid for the year 2011, 12, 13, 14, 15, 16, and 17. After that, we did not pay a fee in 2018. Now, in response to losing the Loving case in 2015, actually 2014, announced for the 2015 season, they are started a voluntary program, which is called an annual filing season program. Preparers who are not CPAs and EAs or attorneys can voluntarily take a test. They will then, if they take a test provided by an approved private provider and they pass, the IRS will include them in the database at irs.gov. Now, what's that database? Those of us on the phone who are enrolled agents, attorneys, or CPAs have our PTIN, and the IRS actually lists us on their website. And I could go in and do a search at the IRS website, and my office happens to be in 60601 in Chicago, Illinois. I could do a search for tax attorneys on the IRS list in 60601 in Chicago, Illinois, and my name would appear along with the other attorneys who are in that zip code. Now, what the IRS has said for this annual filing season program is that if you pass that test, they will include your name on that database. And so the database includes CPAs, enrolled agents, enrolled retirement plan agents, and those who are registered under the annual filing season program. It's one way taxpayers can check the credentials of tax preparers. Now, important in this also is people who choose to participate in this gain an additional right. Prior to the implementation of the annual filing season program, any practitioner who prepared a return for a taxpayer was allowed to file a 2848 power of attorney on their behalf and represent that taxpayer in an IRS audit of that return. With the implementation of the annual filing program, the annual filing season program, the voluntary program, the IRS said that it would no longer accept powers of attorney from the people who had not entered the annual filing season program or who were not an attorney, CPA, or enrolled agent. So about 30 to 40,000 people a year are participating in the program. That means that about 460,000 paid tax preparers are no longer allowed to represent their clients in audits before the IRS using a power of attorney. They, of course, could go with their client, but it takes away the protections the client gains by having one of us attend their audit on their behalf. So that was also added. And as part of the voluntary program, taking that test, getting on the IRS list, the practitioners must comply with 10.51 of Circular 230, which is a provision regarding disreputable conduct. So they're submitting to jurisdiction of the IRS to discipline them because they're in the annual filing season program and have voluntarily chosen to be disciplined. But that still means hundreds of thousands of people out there, including convicted felons and very stupid people, cannot be regulated by the IRS. There is currently proposed legislation in Congress to allow regulation of unenrolled preparers. I will not bet on the chances of it getting to Congress. As of 1/1/16, only enrolled agents, CPAs, attorneys, and ASFPs may represent on a POA, but The annual filing season program people can. The remainder of honor roll people, paid tax preparers, may not.